We do want to talk to you about interlocutory appeals, but more specifically, we want to, as Jody suggested when we were opening the show, we want to talk with you about the Texas Citizens Participation Act, which, if anyone is listening to this and you don't know what that is, you're in for an education. But most folks, I think, who are going to fall within our audience are going to know what the TCPA is.
I've heard it called the Appellate Lawyer Full Employment Act, so I feel like that checks out for the last few years.
I think that's true, but my other nickname for it is stealth tort reform. But I've handled TCPA cases. I'm familiar with the statute, but my level of knowledge doesn't approach yours, Amanda. I mean, you've spent a lot of time over the last several years becoming really, one of a handful of people that just come to mind off the top of my head for folks who do this on a regular basis. So tell us, how did you get to be so embedded in TCPA work?
Well, it was inadvertent. I was asked to give a CLE presentation at the Appellate 101 course that we used to have in person every September and is now coming up on Zoom. But it's a great conference where all of us appellate lawyers across the state like to come together, and especially for the younger lawyers, the 101 course is a great introduction to start building that appellate network. And I was asked to give a presentation on interlocutory appeals generally, not limited to the TCPA. This was back when TCPA jurisprudence was still just developing. The statute had been passed originally in 2011, amended to expand for interlocutory appeals in 2013, and this was shortly after that. So I was still telling lawyers what this statute was. Many had never even heard of it at that time. And as I was preparing to give that presentation, although it was supposed to, and it did cover all types of interlocutory appeals, I saw the writing on the wall that the TCPA was about to have a huge impact on Texas litigation because of the plain language of the statute. And the Supreme Court quickly picked up on how broad that plain text was. It allows for a motion to dismiss of certain types of legal actions, but especially as it was drafted back then, that was a pretty all-encompassing standard. And so Bob Pemberton said, as a justice on the Third Court of Appeals, it is a game changer. And there's really no better quote for the TCPA than that.
I like the quote where he said, if a certain justice on the Court of Appeals woke up one morning and decided that something related to, something to that, and, he would probably be right or something. That's a big paraphrase. And I know you know the opinion I'm talking about, Amanda.
I do.
But yeah, that's absolutely true. I mean, it certainly has been a game changer. In fact, I was telling Jody when we were talking recently that, and talking about this episode coming up, that, I got approached about a TCPA case probably in 2013 or 14. And when the statute was still pretty new, it was about an appeal. And I looked at it and thought, I don't want to touch this. This is terrible. This is a complete loser. Look at this statutory language. And it's taken all this time of folks litigating the granting of these motions to dismiss to kind of clarify that, the statute, it didn't take that long for the Supreme Court even to say it really means what it says. And you're not going to like the scope of the way that we interpret this. But yet it seems like over time, and certainly we'll get to the recent amendment of the statute, but it seems like over time that the appellate courts have kind of sort of the pendulum started to swing back the other way, particularly since we've had a big change in the makeup of our courts, some of our major metropolitan courts in the last election cycle.
Absolutely. The pendulum really started to swing at the very end of 2018. A few opinions came out of our more urban courts in Houston and Dallas, I think one or two out of Fort Worth also, that began to pull back on the breadth of the TCPA. But really, it was 2019 that we saw an absolute flip of movements winning on appeal versus movements losing on appeal. I mean, statistically, the numbers they simply reversed from 2018 to 2019. And now that shift has continued into the first half of 2020. It's a remarkable change. And I've identified, I think, 4 reasons for that change, one of which was the election. And I'm happy to talk about each of those if you're interested. But the election in 2018, what we saw was 26 new Democratic intermediate appellate judges, big D Democrat judges. 19 of those replaced Republican incumbents. But I don't think it is the fact that they were blue. I think it's the fact that they were new. I think regardless of party, the fact that you just had new blood on the court opened them up to being, willing to adopt a revised interpretation, opened judges up to hearing arguments from non-movements against the breadth of the statute that perhaps their incumbent predecessors were just more willing to say, the Supreme Court has said we've got to give the plain text its ordinary meaning. It's very, very broad. Our hands are tied. And I think when you got such a big crop of new justices, they were more willing to break from that pattern.
My personal experience, I think, supports that, because even in Fort Worth and Eastland, where you have all Republican judges, they still started to rein in the scope right around that same time. And it was some of the newer justices that were writing those opinions. So I think regardless of party, I think you're right. They just were more willing to listen to, and maybe even just having seen what had happened over the last few years with the broad expansion of the scope.
Right. Absolutely. The volume of opinions is another reason, I think, for the shift, because you went the first year of enactment, the first year that there were opinions, there were only 2. 1, 2, that's it. In 2020, we already have 110 opinions as of August 12th. So we're looking at over 200 opinions. We're talking about the difference of 2012 to 2020. Think about what that means for the appellate justices and their dockets. How many of these appeals are clogging their dockets, taking their time? I think they finally said enough is enough and realized that unless the interpretation was narrowed, it was just going, every single case was going to have a TCPA motion, and it adds time and expense to civil matters.
And so you overlay within that same time frame the legislative amendments to the statute, which scale it back somewhat in terms of application. Some would say that they didn't go far enough. But the Bob Pemberton, relate to language has been scaled way back. In fact, that phrase was struck from the statute, if I remember correctly.
Correct. That's
so
right.
It doesn't, just existing in the same room as something, no longer is necessarily sufficient to trigger the TCPA. And I don't want to jump too far ahead, because I want to come back to the other reasons that you've observed for the pendulum swinging. But are we seeing any opinions coming out now under the new statute?
This is very exciting, Todd. Just as of yesterday, we got the first opinion under the new text. And then, there was one. I'm always one day behind because it takes Westlaw a day to get them out to me. But in the last 2 days, we've now had 2 opinions under the new text. In just odd coincidence, they're almost exactly the same issue. They both presented declaratory judgment claims, which is now, under the 2019 version, expressly considered a legal action, meaning it's subject to dismissal under the TCPA. And in both cases, the movement argued that the declaratory judgment claim implicated its right to petition, meaning the case should be dismissed. And in both cases, the courts of appeals said no. It is a legal action, it's a declaratory judgment action, but it does not implicate your right to petition. So you have not satisfied your step 1 burden, and the claim goes on. Almost exactly the same issue in 2 cases under the new text, but
good.
Those are the first.
I know that was kind of an unsettled issue before, and I know there was some law out of the Third Court of Appeals on that. That went in a different direction than what one might have thought. But it's kind of nice that, there's a ton of DEC actions filed in the state. it's kind of nice that we've got some early opinions out there that hopefully will offer people some clarity, and we'll see if those take hold or if some of the other appellate districts go a different direction.
Which courts were those from?
It was San Antonio and Houston First Court of Appeals.
Okay.
Awesome.
Good to know.
So before we move on, I do want to come back and hit at least the highlights of the 4 reasons you said for the pendulum swinging back, and of course the election was one. Walk us through the others.
Well, the volume of opinions and the election,
Okay.
and then you mentioned the 2019 amendments. So the effective date of those amendments was not until September 1 of 2019. But the legislature lit the path, right? As of May, we knew what changes had been made. The appellate justices knew the changes that had been made. And I think it allowed them, again, remember, you've got this largely new crop of appellate justices.
Mm-hmm.
The legislature has already told us that we are intending to pull this back, and some courts have interpreted the amendments as instructive about the original intent under the prior language. And so they've used the amendments even prior to the effective date to say, well, the legislature clarified what it meant originally. So it really cannot be overlooked, even though we haven't had a lot of appellate opinions decided under the amended text. Those amendments very much have shaped the interpretations from May 2019 on. So that's reason number 3. And reason number 4 is the Texas Supreme Court's opinion in Creative Oil versus Lona Hills. That came down December 2019. It has been cited so many times. I can't remember, probably 80 times since December of 2019. In that case, the Texas Supreme Court really did a pivot in its interpretation of the free speech component of the TCPA and what it means to be related to a matter of public concern. The Texas Supreme Court said that a business dispute between 2 parties that affects only their own pecuniary interests does not, under any sense of the word, have a broader impact on an issue of public concern. And so breaches of contract between 2 parties that don't otherwise implicate the public or a publicly debated issue in society is just not going to satisfy free speech. That shifted what so many courts had previously been holding under the plain text interpreted by the Texas Supreme Court in some prior opinions, primarily the ExxonMobil versus Coleman opinion, which was an employment dispute, and the communications in the employee file about the employee's performance at work were deemed to satisfy the public concern component because it was in the oil and gas industry. Many courts of appeals took that and ran with it on a very broad basis up until the Supreme Court issued Creative Oil. Although they did not overrule Coleman and some of their other prior broad interpretations, the court did distinguish those cases, and the courts of appeals have since cited Lona Hills as a shorthand reference to, this is a business dispute, it's not getting dismissed under the TCPA. That's been a huge change.
Well, and you've got that gap between the time the amendment was announced and the time it went into effect. And as you point out, the amendment coloring arguably at least a statutory interpretation argument. And then you've got the issue of, we're not going to fool around with these things anymore. I mean, it seems like the courts of appeals, I mean, they were just getting beaten down with, and still are, I suppose, beaten down with these cases. And it's like, look, stop bringing this nonsense to me that, somebody's private conversation in a business context can be a matter of public concern.
Mm-hmm.